Dean Rusk as our speaker this morning. Professor Rusk's outstanding accomplishments as a scholar and statesman are well known. A native Georgian hailing from Cherokee County, he attended Davison College in North Carolina and was a Rhodes Scholar at St. John's at Oxford. Professor Rusk studied law at the University of California at Berkeley. In 1947, he joined the Department of State as Assistant Secretary of State for United Nations Affairs and Far Eastern Affairs. In 1961, he rose to Secretary of State in the Kennedy administration. We are privileged to have him at the University of Georgia School of Law as a professor of international law, and we are privileged to hear him speak this morning. Ladies and gentlemen, Professor Dean Rusk.
Thank you. Thank you. Thank you, Rita Capitan, members of the graduating class and your guests, President Davison, Dean Beard. I was deeply complimented by your invitation to have a little part in this happy occasion this morning. President Davison, Mrs. Rusk and I consider ourselves extraordinarily fortunate to have been a part of this university during those years when your superb leadership has done so much to lift this university into the front ranks of American universities. And we're grateful to you for the exhilaration of those years. Dean Beard, when I was studying law at Berkeley before World War II, it was my fondest hope to become a professor of international law. And after a 30-year detour, I finally made it. So we're grateful to the students and the faculty and the administration of this fine law school for 16 of the happiest years of our lives. Since I am the final obstacle between you and your degrees, I shall be brief. When we think of creativity and invention, our minds usually turn to the artists, the scientists, and those who are working in the fields of technology. Usually overlooked is the extraordinary creativity of the law over the centuries, which has contributed so much to the well-being of mankind throughout the world. At the moment, I cannot think of a so-called law in the natural sciences, which is as old as the simple legal idea, pacta servanda sunt, agreements are to be kept, a notion which is at least as old as the wheel. And over the years, law and the lawyers have fashioned the institutions and the procedures by which, among other things, we settle our differences among ourselves, usually by peaceful means, and we can bring to bear to the service of mankind the great contributions of science and technology. One thinks of the law merchant. One thinks of the great codes of Hammurabi and the books of Moses and of Justinian and Napoleon, a process which has such a strong influence upon all legal systems, including our own. We think of the procedures by which we have powerful means for mobilizing capital, and such things as the joint stock companies we now call corporations and other procedures. Because without those contributions of law, much of the benefit of science and technology perhaps would have been lost to the human race. Along the way, we learned that the profit motive is a powerful dynamo in driving a free enterprise economy. But in this past century or so, we have also learned that that profit motive can become that overweening greed which can destroy the capitalist system itself. And so beginning with President Theodore Roosevelt's trust-busting campaign, we've had to devise ways and means of protecting capitalism from capitalists through such things as antitrust, the Federal Reserve System, the Federal Deposit Insurance Corporation, the Food and Drug Administration, the regulation of certain monopolies, usually public utilities, and so forth. Now, when we think of creativity in the law, our mind necessarily turns to an extraordinary act of creation which we shall be celebrating for the next 3 years, an act which produced the Constitution of the United States. And when we think of the Constitution, we properly remind ourselves that we are the heirs to several centuries of constitutional struggle in England, through which constitutional restraints were placed upon the exercise of the raw powers of the state. A moment which I shall always cherish was the privilege I had in 1965 in going to Runnymede, the field of Magna Carta, and there receiving from Her Majesty the Queen an acre of ground at Runnymede as a gift to the American people in memory of John F. Kennedy. Now, this pleasant sentiment that each of us owns a little piece of Runnymede helps to remind us that our own constitutional history merged with that of England in the latter part of the 18th century, and that the Petition of Right of 1628, the Habeas Corpus Act of 1679, the English Bill of Rights of 1689 are all a part of our own constitutional history. And one thinks of some of those old common law judges locked away in the dusty pages of Holdsworth's great history of English law, are accounts of some of those old judges who, at the risk of their own lives, over against the crown and sometimes a hostile parliament, put their arms around a prisoner at the bar and said, "You cannot do this to this man." And so, if I may abuse a metaphor, gradually over a period of time and with much struggle, we took the old notion that the king can do no wrong and transferred it into the notion that if it is wrong, the king cannot do it. The English wound up with a system headed by the notion of parliamentary supremacy, but a parliament which traditionally respects the great constitutional customs of the country. In this country, our founding fathers took a little different direction. By the way, among the 55 members of that Constitutional Convention, 30 were lawyers. And beyond that, familiarity with the law was a part of the general education of men of affairs of that day. And so they labored well, and in secret, by the way, and produced a written constitution to operate as the supreme law of the land, enforceable by the courts at times over against both the executive and the legislative branches of the government. Now, if any of you have the idea that Chief Justice John Marshall invented the idea of judicial review in the case of Marbury against Madison, you can go back to the Federalist Papers and discover that that was a familiar concept of the day, because the Constitution was the beginning point for determining what is the law. The late Chief Justice Earl Warren came to this law school shortly before his death, and on that occasion reminded us that if each branch of the federal government were to pursue its own powers to the end of the trail, our system simply could not function. It would freeze up like an engine without oil. Now, the impasse is the theoretical chief threat to our constitutional system. But if the separation of powers is a fundamental notion in our system, the other side of that same coin is the constitutional necessity for comity and cooperation among the branches of government. Our Constitution forces us to seek a consensus, and that has been a powerful element of strength in our constitutional system, at least in the last 100 years or so. Now, if you consider the first 10 amendments as a part of the original Constitution, which is entirely appropriate, and you dismiss the 2 amendments on prohibition, which canceled each other out, we have amended our Constitution only 14 times in 200 years. And those amendments have had to do with process, the election of senators, a 2-term restriction on the presidency, votes for women, votes for 18-year-olds, provisions for the disability of the president. We have not thus far cluttered up the federal Constitution with those matters which can be dealt with by legislation. And we have not thus far started down the trail which would produce the kind of jungle in the federal Constitution which we find in so many of our state constitutions. I hope we can respect that tradition, but I'm not entirely sure about the future. In early February, we were treated to a rather remarkable bit of irony on which there was no comment at the time. On a certain Tuesday evening in early February, President Reagan went to a joint session of Congress to deliver his State of the Union address. On the very next, in that address, he called for a constitutional convention to require a balanced federal budget. On the very next day, on the Wednesday, he submitted a budget to Congress with a deficit of $150 billion in it. Now, one can only speculate as to what he would have done on Wednesday had his proposal of Tuesday been in effect. The truth is that the President and the Congress already have the constitutional power to balance the federal budget. And they would not dare adopt such an amendment without an exception clause for times of emergency. And until such time as the President and Congress are prepared to balance the federal budget, they would simply live on that emergency clause. So at best, such an amendment is much ado about nothing, and at worst it is playing a cynical game with the great creation of our founding fathers. When it seemed apparent that the Equal Rights Amendment would not make its course to the very end, I suggested to some of my friends interested in that movement that they might consider doing the same thing by legislation. Section 5 of the 14th Amendment clearly gives Congress the power to enforce the provisions of that amendment. And it would be relatively simple for Congress to declare that the equal protection of the law shall not be abridged, and then pick up the, the language of the United Nations Charter, which is already a part of the law of our land, shall not be abridged on account of race, sex, language, or religion. For whether the idea is inscribed in statute or by constitutional amendment, the courts would still have to find what are the reasonable classifications which permit some difference of treatment between male and female. Now, I must confess that, and I may be told branded a male chauvinist for this, I must confess that it's difficult for me to find constitutional underpinnings for a regulation stating that public schools cannot have all boys choruses meeting after school unless they have reached the age in which their voices have changed. Otherwise, they must have girls in those choruses. And I am not particularly enchanted by the notion that women sports writers have the right to wander around the locker room following a game. I wonder what old Benjamin Franklin would have thought of such a thing. Well, knowing something about the old man, my thought is that he would simply put on the door of the locker room a sign saying, "If you come in here, you must dress as we do." But nevertheless, this is a Constitution which has served us extraordinarily well. It has proved to be a living instrument, as some of our great judges have described it. It has adapted itself to the changes in life, and those have been extraordinary since the days of our founding fathers. So we have something to celebrate in these next 3 years. Now let me make a few comments about a speech which I made 30 years ago, which was not listened to by those to whom the speech was made. I'd been invited to speak to the alumni of the Harvard Law School in New York City. And since there are a lot of those people around there, there was a large turnout at the Harvard Club there. Seated just to my right was Judge Learned Hand. And by that time, he was getting quite old and indeed quite deaf. And as I spoke, he would tug on my coat and say such things as, "That's the stuff. Pour it on. Give it to him." And what he thought was a whisper was picked up by the microphone and carried all over the room. And so the audience became so enchanted with wondering what the old judge was going to say next, they paid no attention whatever to me. I had made a study of the curricula of liberal arts colleges at that time and found that although liberal arts colleges claimed to talk about life as a whole, almost none of them said anything about the law, despite the fact that law is the most pervasive part of our human environment in the course of our daily lives. We may differ among ourselves as to the philosophical or religious origins of our individual liberties, but out there in the real world, these liberties are validated largely by law. From the moment each one of us wakes up in the morning until we go to sleep at night, we pass through hundreds upon hundreds of actual or potential legal relationships. Now, many of them are not activated because we don't punch in the nose everyone we pass on the street. But nevertheless, it is the law which permits us to predict with a high degree of accuracy how others are going to act, and permits each one of us to pursue our eccentric orbits with a minimum risk of collision with others. Now, those who have the greatest stake in the law are those who want to be most different, because it is the law that prevents their being snuffed out like gnats by the overweening majority. Indeed, under our constitutional system, we have a constitutional democracy, which does not mean that the passing whims of a majority can carry the day as far as the law is concerned. So let me just say to the members of the graduating class that you are entering a profession which at its best has been a noble profession. We still have a great deal of unfinished business ahead of us to which you must address yourselves during the decades which belong to you. I have in mind, for example, the war which is being waged on our society by organized crime, particularly those elements in it which fatten themselves by feeding poisonous drugs to children and adults alike. I'm thinking of arrangements which we are going to have to make to prepare for the day when the oil reserves of the world begin to diminish sharply, and the increasing care we will have to take to be sure that mankind itself does not inflict irreparable damage upon this thin biosphere in which our species must live. And I think of the prospect that one of the oldest causes of war in the history of the human race, the pressure of people upon resources, is being revived by exploding populations in a world in which destructive power is almost beyond imagination. And so among the assets on which you can build is the creative capacity of law. Whatever you do in your personal lives and your private practice, the mantle of statesmanship falls upon you. You cannot avoid it, whether you like it or not. And so you will be called upon in your own communities and in the state and nation as a whole to think again about those great creative contributions made by lawyers in law over the centuries. And I would urge you to move into the future with hope, and confidence, two essential ingredients for a democratic political system and a free enterprise economy. Because we are passing on to you more than 40 years since a nuclear weapon has been fired in anger. That is something of some importance, because if we should ever have a nuclear war, it would not only eliminate the answers, it would eliminate the questions. And Mr. Khrushchev was not kidding when he once said, in the event of a nuclear war, the living will envy the dead. Nevertheless, despite some of the doomsday talk you hear, I myself cannot put my finger on a real situation in the real world which is pointing toward nuclear war. And so I would urge you to move ahead with confidence. You're going to make it. I have no doubt about it. None whatever. I shall not be able to travel with you along that journey, but I assure you, you will never have a dull moment. And in any event, you take with you the best wishes and the blessings of an old man. Thank you very much.
Thank you very much, Professor Rusk, for those stimulating and thought-provoking remarks. Since 1970, the Georgia Law School has been the beneficiary of your treasure house of ideas and values. The eloquence of your speech and the wisdom of your words have always stimulated your audiences. This is true whether you're speaking to the United Nations, the British and American dignitaries at Runnymede when you accepted that plot of land on behalf of the American people, or to a fourth grade class assembled on the steps of the Rusk Center. The graduating class whom you see before you today did not have the opportunity to register for your Introduction to International Law class, which regularly drew an enrollment of over 200 during the 14 years you handled classroom duties. But they are the direct and indirect beneficiaries of the work you continue to do since your semi-retirement. As the class leadership told me, they wanted a living legend as their graduation speaker, and that is exactly what they got. Thank you. To all of you who will receive degrees, with today's ceremony, the first phase of your career preparation is completed. As soon as the bar results are known, and they should be coming out at the end of this month, you will make the transition from a student of the law to a practitioner of the law. As an attorney, you will occupy a position of trust. Each person you counsel will depend upon you for guidance and will rely upon your sense of judgment. Weigh very carefully this responsibility. This is the essence of professional responsibility. It is certainly more than the title of a course which some of you grudgingly completed in law school. It is a working standard of honesty and integrity which all who enter the profession take an oath to uphold. One caution that I would address to all the lawyers in the audience. Keep in mind that you are always an exemplar, whether you want to be or not. This year, the 126th year since the study of law was developed into a formal degree program at the University of Georgia, you will join 4,500 living alumni who have earned law degrees at this institution. You have been preceded by men and women who have distinguished themselves in all areas of the law. At the end of this day, you will have a diploma which is highly valued in our society and from an institution which is held in esteem among the nation's 174 law schools. It is now a special personal privilege to call upon the President of the University of Georgia to confer the degrees upon the candidates that have been certified by the faculty as having met the requirements of a Juris Doctor degree. Before Dr. Davison comes forward, however, I'd like to take a moment to comment on the legacy of the Davison years at the University of Georgia. 19 years of substantial and far-reaching achievement by a man whose educational vision and sense of mission have moved this university to a new level of excellence. Fred Harrington, President Emeritus of Wisconsin University, an observer of higher education for a long time, noted some time ago that only 2 presidents, that is, university presidents, in this century have moved their institutions to new levels of accomplishment. One was John Hanna of Michigan State, and the other, Fred Davison of Georgia. The School of Law has been a direct beneficiary of his philosophy and style of educational governance, which is, reach as far as your aspirations for excellence and capacity for achievement will take you, and the resources to carry out your mission will follow. He has been one who will listen patiently to a plan of action, probe, ask questions, satisfy himself that the undertaking is educationally sound, and then work to get you the resources to make it happen. He has encouraged and demanded high performance through a system of autonomous, independent schools and colleges who are free to carve out their national reputations in the disciplines for which they are responsible. The progress of this university since 1967 has come about because of his willingness to stimulate and encourage self-achievement. The J.D. diplomas presented here today will be the last ones to have the signature of Fred C. Davison. It is indeed an appropriate occasion to thank him for the foundation of progress which he has laid for this university. The proof is all around us in these buildings and grounds, yet the real proof of his remarkable presidency is in the outreach of service, research, and instruction for which the University of Georgia is now known around the world. Over the years, his relationship to the law school has been recorded in many ways, particularly in the last 2 accreditation reports, but also in the law school's alumni magazine, The Advocate. And as you come forward, Mr. President, to confer these degrees, I would like to confer on behalf of the 4,500 alumni this pictorial history from The Advocate, which catalogs this relationship. Come forward.
Thank you, graduates, family, friends. It's a great honor to be here, and it's a pleasure to join Dean Beard and the faculty in welcoming the families and the friends of the graduates to this ceremony. It's an honor to share this special day with you and to share it with these young men and young women who have completed a rigorous 3-year educational journey to arrive at an important milestone. It's also a personal pleasure, and it's a great honor to share this podium with one of my real heroes, Professor Dean Rusk, great Georgian, a man who has contributed so much to his state, so much to his nation, and so much to this university. I'm reminded as I stand here today of the first occasion when I individually congratulated law graduates. Until that time, this graduation had been part of the regular university graduation, a much larger event. That was in 1974. In 1974, Dean Beard persuaded me to break with tradition and to allow the law school to hold a separate diploma ceremony following the general commencement exercises. The law school has never done things like everybody else, and that's probably the highest compliment I can pay it. When I became president in 1967, several areas of excellence were identified for special support, since these programs, in my opinion, had the most potential for academic achievement. The School of Law was one of these, and it has taken quantum steps in its national standing, in its program quality, in the caliber of faculty and students it attracts, and most importantly, in the results it achieves. You, the graduates of 1986, should be proud of your achievement in completing a legal education, but you should be extraordinarily proud to be graduating from one of the nation's finest law schools, a fact that I assure you will have even greater meaning with each successive year of your legal careers. And much of that credit goes to its leadership. I appreciate all of the nice things that have been said about me, but I'll share a secret with you. Being a successful university president is really not that complicated. All you have to do is to pick good deans. And your success comes to be the algebraic sum of those activities. And I can say in an unqualified way that this institution, this School of Law, in the person of Ralph Beard, is blessed with the finest law dean in this country. And Ralph, we thank you for bringing so much vision, so much energy to the task of guiding the Lumpkin Law School. Again, my congratulations to each of you graduating today, and my sincere best wishes for a successful life. You have achieved something which should make you extremely proud, and I join your families and friends in expressing our pride in you. And now, by the authority vested in me by the Board of Regents, I confer on you and each of you the degree Juris Doctor which you have earned and for which you have been recommended by your dean and faculty with all of the rights and privileges appertaining thereto. Congratulations to you.
The class of 1986 chose as faculty marshals Professor Julian McDonald and Ronald Ellington. If they will come forward. As they call the name of the graduate, I will ask that you come in this direction and receive from the president your diploma. If any of you have cameras and would like to take a picture of this momentous occasion, well, please feel free to come forward as your son, daughter, wife, husband comes through.
Amy Elizabeth Abernathy. Jonathan Augustus Alderman. Linda Margaret Anderson. Tracy Robin Aronovitz.